Committees on Public Safety to hear the Firearms and Ammunition Sales Initiative. First, I want to welcome everybody to the joint hearing by the Committees on Public Safety. This year's proposed initiative on firearms and ammunition sales, I think we'll have quite a enthusiastic discussion on this. The purpose of this hearing really is to educate ourselves and the public as to the specifics of the ballot initiative, and to provide a forum for public participation, which is probably the most important part for us, not only on the committee, but for the general public. I recognize that anything that deals with firearms can be very divisive and often a very, very emotional issue. I just want to remind everyone to be respectful of divergent points of view. Everyone's view will be respected, and I can assure you that both on the Senate side and the Assembly side, all information that is heard today will be given the full magnitude of consideration as we move forward. While our respective committees have already examined many of the issues that will be brought forth by this proposed initiative in the form of prior legislation, I look forward to hearing testimony from both sides, as well as the findings from the Legislative Analyst's Office and comments from the public. I also wanted to thank the members of the Public Safety Committees who have spent hours and hours and days preparing us for this time, and for taking the time to participate in this informational hearing. And with that, I will give it over to my colleague, Lonnie Hancock, Chair of the Senate Committee on Public Safety, and I like to say all the time, my partner in crime.
Yes, we do that quite a lot, actually. Thank you, Reggie, Assemblyman Joan Sawyer, and we are all looking forward to what we're going to find out at the hearing today. We know that the Elections Code specifically calls for a hearing, an informational hearing. No action will be taken today on what is in the initiative. We have no authority to alter the initiative measure or prevent it from appearing on the ballot. This is just to make sure that we all can thoroughly discuss the provisions that are in it. As Assemblyman Joan Sawyer said, this ballot measure addresses a very, very serious public issue with great implications for the safety of all the communities in California. So we look forward to what we're going to learn today. And are there other members of the committees that would like to make a comment before we begin? Assemblyman Quirk?
For the people who are testifying today, thank you very much for being here. I really appreciate your taking your time to do this. And to the chairs, thank you very much for holding this hearing. I very much appreciate the time you've put in, as well as that the staff has put in preparing for this. My concern for the people who are testifying deals with increased costs to the state for regulation, for courts and law enforcement, and also for correctional. Increased penalties, I keep on voting against them in committee and not voting for them on the floor. I am very concerned about that particular both cost and like to hear what you feel the implications are. So those are my requests, and hope to hear about them as we go forward.
Okay, anyone else? In that case, we will first hear from Ms. Anita Lee from the Legislative Analyst's Office. Ms. Lee will be followed by the proponents panel, an opponents panel, an opportunity for public comment. Ms. Lee, thank you for being here, and please start us off.
Great. Thank you so much. Anita Lee with the Legislative Analyst's Office. The sergeants have distributed a handout that we will be using as a guide today for our comments related to this proposed initiative. If you turn to page 1 of the handout, we first provide an overview of the LAO's role in the initiative process. And the LAO is really involved in at two different distinct points in the process. The first is that state law requires our office to work with the Department of Finance to prepare a joint impartial fiscal analysis of each initiative before it can be circulated for signatures. State law requires that this analysis provide an estimate of the measure's fiscal impact on the state and on local governments. The analysis must be submitted to the Attorney General's office within 50 calendar days of the initiative's submission date. A summary of the estimated fiscal impact is included on the petitions that are then circulated for signatures. The next point that the LAO is involved in the process is after an initiative collects sufficient signatures to qualify for the ballot. At that point, state law requires our office to provide impartial analyses of all statewide ballot measures for the statewide voter information guide, and that will include descriptions of the measures as well as its fiscal effects. We are currently in the process of preparing those materials for the November ballot. If you turn to page 2 of your handout, we provide some background on the current regulation of firearm and ammunition sales in the state. First, under federal and state law, certain individuals are prohibited from owning or possessing firearms. Such prohibited persons include individuals who are convicted of felonies or certain misdemeanors, those found by a court to be a danger to themselves or others due to mental illness, and those subject to a restraining order. In California, individuals who are prohibited from owning firearms are also prohibited from owning ammunition. Next, both federal and state law have regulations pertaining to firearm sales. Under federal law, firearms dealers must request background checks from the National Instant Criminal Background Check System, or NICS, of individuals seeking to purchase firearms. NICS searches a number of federal databases to ensure that the purchaser is not a prohibited person. As permitted by federal law, California chooses to process these requests, which then also allows it to search various state databases to ensure that the individual is not a prohibited person. DOJ, California DOJ, also maintains a database that matches the state's prohibited persons list against the state's list of firearm owners. This allows DOJ agents to then seize firearms from individuals who have become prohibited after legally purchasing their firearms. Other state regulations related to firearms include a 10-day waiting period before a firearm may be transferred to a purchaser and various reporting requirements related to firearms purchases. Fees charged to firearm vendors and purchasers generally offset DOJ's costs related to regulating firearm sales. If you turn to page 3 of your handout, in contrast, federal and state laws generally do not regulate ammunition sales in the same manner as firearm sales. However, there are some state regulations that apply to ammunition generally. So for example, since 2000, state law has banned large capacity magazines, which is defined in law as ammunition feeding devices with a capacity to hold more than 10 rounds. However, individuals who possessed large capacity magazines before 2000 are allowed to keep them for their own use. Turning to page 4 of the handout, we shift our attention to the major provisions of the proposed initiative. The first major provision is that the initiative proposes to regulate all ammunition sales in a manner similar to firearm sales, and there are a few components here. The first component is ammunition vendor licenses. The measure generally requires that individuals or businesses obtain a 1-year ammunition vendor license from DOJ to sell more than 500 rounds of ammunition in a 30-day period. Firearms dealers that are licensed by the state and federal government would be automatically deemed a licensed ammunition vendor. DOJ would be authorized to charge a fee to offset its costs related to these provisions. The second component is ammunition purchase authorizations. Individuals who purchase authorization would be required to obtain a 4-year ammunition purchase authorization from DOJ and must be 18 years or older and not a prohibited person. DOJ could charge a fee of up to $50 per person, adjusted annually for inflation, to offset its costs related to administering this section. Before a transaction, ammunition vendors would be required to verify with DOJ that an individual has an ammunition purchase authorization. Vendors would also be required to report certain information, such as the purchaser's identification information and the type of ammunition purchased, to DOJ for retention in a centralized database. The final component of this regulation is kind of a whole bunch of requirements related to ammunition. For example, it requires that nearly all ammunition sales, including internet and out-of-state purchases, be conducted through a licensed ammunition vendor. Turning to page 5 of your handout, the next major provision is that the proposed initiative would implement a new court process to ensure that individuals who are convicted of offenses that prohibit them from owning firearms would surrender them near the time of conviction. For example, it requires that probation officers report to courts on whether offenders have actually surrendered their firearms. If a court finds that an offender did not surrender his or her firearms within 14 days of sentencing, the court is required to order that the firearms be seized. Local government and state agencies would be authorized to charge a fee to reimburse their costs related to the seizure of the firearms. On the second half of this page, there are approximately 3 other major provisions that we would like to bring to your attention. The first is that the measure would generally ban all large capacity magazines. Individuals who possess these magazines would either have to remove them from the state, sell them to a licensed firearms dealer, or surrender them to law enforcement. Second, the measure includes a number of reporting requirements related to firearms and ammunition. For example, the measure requires that ammunition vendors would be required to report the loss or theft of ammunition within 48 hours, similar to current requirements related to firearms. Finally, the measure proposes some changes to the penalty for the theft of firearms. Currently, theft of firearms worth $950 or less is generally a misdemeanor punishable by up to 1 year in county jail. Under this measure, theft of a firearm would be a felony crime punishable by up to 3 years in state prison. Additionally, individuals convicted of a misdemeanor for the theft of a firearm, such as those convicted before the measure would be enacted, would be prohibited from owning firearms for 10 years. Turning to the final page of your handout, page 6, we've identified 3 major state and local fiscal impacts from the proposed initiative. The first is that the measure would result in increased state costs to support new DOJ regulatory requirements. Some of these costs would be one-time in nature, such as for the development of the various databases, and some would be ongoing, such as for staff to process the authorizations. These costs would likely be in the tens of millions of dollars annually, but would likely be offset by various regulatory fees authorized by the measure. Second, the measure would likely result in increased court and law enforcement costs. The state trial courts, as well as state and local law enforcement, would likely experience workload related to the new court process and the removal of firearms. The total magnitude of the costs associated with this workload is unknown, but could be in the tens of millions of dollars annually. Actual costs would depend on how this measure was implemented, such as whether existing resources were reprioritized to accommodate the workload. Additionally, some of these costs would be offset if local governments and state agencies charged and collected fees as authorized by the measure. Finally, the new and increased penalties that are authorized by the measure could result in increased correctional costs to state and local governments. The magnitude of these costs would depend primarily on the number of violations and how the provisions of the measure are enforced. Thus, the potential increase in cost is unknown, but would unlikely exceed the low millions of dollars annually. With that, we've concluded our comments and are happy to answer any questions you might have.
Thank you, Ms. Lee, and it's, as the former chair of Budget Sub 5, it's good to see you here. And I know we've had numerous discussions on funding. And the thing that has always been frustrating for me, I have this saying all the time, that the key to what we do is not necessarily legislation, it's more about implementation. And a lot of times we have great legislation, but if it's not implemented right, it falls by the wayside or it doesn't get fully done. With that said, and I'm probably channeling Assemblymember Jim Cooper now, but he's always made a very cogent point. Are we giving DOJ enough money to be able to get the job done? And I think we've tried in our budget subcommittee on several occasions, whether it's droves or drugs or things of that nature, and with other legislation coming in for adult use marijuana, this could be an extremely large load on the department to try to administer if both these initiatives were to pass. And so one of the frustrating things for me has always been when we ask DOJ if they need any money, a lot of times they say no, and then we have a large backlog. And that could be very frustrating, not only for the proponents of any legislation, but the opponents. It can be very frustrating. And so I want to make sure that whatever we propose, one, that DOJ fully understands that they need to ask for all the resources that they can, so this body and the governor can provide that. And if there's a way to ensure we can do that. And then two, whatever monies we give to them, because this has been another criticism, that those monies that go toward this initiative stays in this initiative and it doesn't get moved over to do something else. And if there's a way to ensure that the monies that we collect for this initiative stays here and it can only be used to this and can't be siphoned off for something else, because I think that further diminishes our ability to regulate this in an effective manner. So I know that's a lot, but again, can you comment?
Sure. So in preparation, when we prepare our fiscal impact letters in our analysis, we talk to both the proponents and the opponents. But as part of our work, we also reach out to the departments. So related to this initiative, we have had conversations with DOJ, we've had conversation with the courts, et cetera. So specifically related to DOJ, there are certain uncertainties about the amount of revenue that would come in and then the expenditures that go out. So one of the things that I mentioned was the measure requires the ammunition purchase authorizations, and DOJ can charge a fee of up to $50, adjustable for inflation. So there are kind of a few key questions, I think, in terms of the revenue. How many individuals will actually be coming forward to purchase these authorizations? We're not quite certain. We have to make certain assumptions. But then there are also questions in terms of at what point do they come forward? Is it in year 1, year 2, year 3, at what point? The other thing is then accordingly on the expenditure side, DOJ would need to ramp up at some point. There are kind of these initial one-time costs in terms of developing the database, et cetera. There are certain parts of the initiative that don't go into effect immediately. So not, you vote, it gets enacted and then it goes into effect. There's a little bit of a delay. And so I think part of, in our conversations with individuals, part of that is to allow for planning and kind of ramping up for that. I think as the measure would, to the extent it was enacted, I think that the legislature could certainly have conversations with DOJ about whether or not the revenue is sufficient to then match their expenditures. I think at this point, as part of our conversations, we have been having those conversations, and we think that a good chunk of that, if a large portion of that would be offset by the fees that are collected. The second piece in your question in terms of making sure that the funds are dedicated and kind of partitioned off. The initiative does create 2 special accounts. Both are continuously appropriated. One is for the ammunition vendor license fee, and then one is for the ammunition purchase authorization fees. And so the money is kind of separated. So you referenced kind of the budget process. You would think of it like, the same way we have a DROS account, we're going to have kind of 2 new special funds related to this measure.
Okay, and so I just want to ensure that we have an understanding of how it's spent, because I think some of the discussion we've had, for example, with the DROS account, monies were spent, and in our committee, subcommittee, we had long discussion that may not have been the appropriate way to spend it. So it sounds like the initiative doesn't have any guidelines for that, and that may be something we need to express early on, how the money should be spent, so there won't be any misunderstandings or other interpretations later on.
There is, in creating the special fund, there are certain guidelines. For example, it makes reference to implementation or enforcement of this program or these provisions. But in terms of your larger question about kind of legislative involvement, even though the funds are continuously appropriated, the legislature could certainly ask DOJ to come forward and discuss its expenditures, discuss its plans for implementation. The legislature can certainly do that.
Thank you.
Yeah, Ms. Lee, just to follow up on those, do we have an estimated number of people who buy ammunition in California? Presumably, that would be all gun owners.
Yes. So there is no database that kind of collects this information on the number of ammunition purchasers. In our fiscal impact, and we are, looking at our model again, because as I mentioned, we're currently in the process of preparing our ballot measures, but we do make certain assumptions about the number of ammunition purchases that would potentially happen based on the number of firearms owners.
And are we assuming that the background check would be roughly similar to what someone goes through now to become authorized to own a gun?
I think so. I think that there are a few technical issues that I think DOJ would potentially need to work through, but that is going to be more of an implementation issue.
So that could be done fairly quickly and efficiently.
I think so.
Yeah. I think for the purchasers, right?
Yes. I mean, I think that there are, like, as I mentioned, implementation issues that DOJ would need to work through, including how the new databases are kind of constructed, how the information is stored, and how the information communicates with one another. I think that's one of the discussions that both budget subcommittees have discussed related to firearms.
So, and these would presumably be ongoing positions, since after the initial sign up, the authorizations would have to be renewed every year in the case of a vendor, or every 4 years?
Yes.
In terms of an individual purchaser. And did you do any calculations as to whether the $50 fee would cover that cost?
I think it really depends on the number of, the large variable is the number of individuals that come forward to seek the ammunition purchase authorization. Based off of our assumptions, we think the bulk of the costs would likely be covered. But on the expenditure side, it also relies on, DOJ not coming across any unexpected issues in terms of developing the database and things like that.
Because the vendor license, we must have business licenses, hopefully, for all these people now, right?
So on the vendor licenses, our firearms dealers have licenses and kind of are regulated that way. Licensed firearms dealers would automatically be deemed ammunition vendors, and so they would not be kind of captured here. Here, in terms of the licenses, it would be individuals who purely sell ammunition, and there is kind of a question about how many businesses or individuals that would encompass as well.
Yeah, might not be too many. But what about mail order sales? And what I'm thinking about is one of the cities in my district discovered a number of years ago that there were people selling firearms who had never taken out a city business license. But they were federally licensed in some way and dealing with quite large numbers of guns and ammunition.
So the measure does require that any internet purchase or, more remote type, which I think would encompass the mail order, would have to be processed through a licensed ammunition vendor. So that is included in the measure.
We would find that out. Now, I know there is some pending legislation that is somewhat similar to this provision in the initiative. Are you familiar with it? Is there any quick comparison you could give us?
So there are a number of pieces of legislation that touch on different parts of this initiative. Senator Hancock, you actually have one of them related to the large capacity.
That's the high-capacity magazine.
Yes,
Right.
exactly. But there are other ones, including Senator De Leon has one as well. I would break it into kind of three classifications. I think the first piece is that there are some things that are exactly identical. So for example, the definition of ammunition. I think then the second area is related to touching on the same issue, but choosing a different approach. And so to give you an example on that, Senator De Leon's bill takes a different choice and a different tact on how to do the ammunition purchase authorizations and how ammunition sales will happen. And so that's clearly, a decision that the legislature will be having discussions about. And then I think the third area is that there are some components of the initiative that are not included or not touched on by any pieces of legislation. Most notably, I think the new court process. I'm not aware of any legislation that kind of touches on that piece. But vice versa is also true. There are certain pieces of legislation that touch on areas that the initiative doesn't touch on as well.
Okay. Thank you.
I don't know who hands were first, but I'll start with the budget chair because I need to grovel to him later. So, Mr. Leno.
Good decision, Mr. Chair. Thank you. I will be as succinct as possible. I do have a number of questions, somewhat following up on a number of points that both of you have raised already. You had mentioned, Ms. Lee, that the new special funds would be continuously appropriated. I would imagine they'd be appropriated to DOJ in most cases for their costs.
I think that that is the idea. The way the legislation reads is that the funds are continuously appropriated, but I think that that's the general understanding.
Now, since we don't know how many people will proactively step forward to either get the vendor license or the individual purchasing license, we don't know how much money will be in those funds. So the measure doesn't, it just says funds will be continuously appropriated. It doesn't say to whom or in what amount.
So in terms of the first question, or the first part of your question, in terms of kind of the initial startup costs, the measure does authorize a $25 million loan from the general fund initially for startup costs. And so that would cover kind of the initial portion, development of the databases and things like that. And then on the special funds, once the fee revenue is kind of coming in and it's being collected, there is language then that one continuously appropriates the dollars for kind of support of the program, which I think is what we would interpret to mean DOJ, as well as to repay that loan.
Okay. And as the chair had pointed out, the dealer record of sale account use is specified very clearly in statute. In fact, we had to amend it slightly so it could be used for the purpose of confiscating those who are prohibited from possessing weapons. So the measure does not have those kinds of details in it. Is there, that's question one. And number two, if there are no details in the measure as to exactly how these new funds can be used, is there anything that would prohibit the legislature from coming back with legislation specifying how those funds can be used?
So the language inside the initiative is a little bit different from the language that is related to DROS, which you are familiar with.
Yes.
The language here is more in line with, and I'm kind of quoting from the initiative, are continuously appropriated for the purposes of implementing, operating, and enforcing. And it depends on how you interpret each of those different clauses. And in terms of the legislature kind of providing further clarification, the measure allows for legislative action if it's furthering the purposes of the initiative by a vote of 55% of both houses. To the extent, though, that the legislature was interested in making changes that conflicted with the initiative, then it would require a vote of the people.
Of course, okay. And then with regard to your point made on the bottom of page 4 that nearly all ammunition sales, including internet and out-of-state purchases, be conducted through a licensed ammunition vendor. Is there any way to really enforce that? Because that internet seller could be anywhere on the planet, right?
Yes. So this is a question that we discussed with the DOJ, and I'm sure we'll be having further conversations on that. I think that they would kind of compare it to similar restrictions that are currently in place related to firearms, and so that there's an onus on both who is selling it, you know, remotely if they're kind of out of state, as well as on the purchaser. And so one of the examples that I was given is, you know, if you're purchasing a firearm out of state and there's notifications on the website that says, you know, to the extent that you purchase it, there are, you know, there may be other state laws that prevent us from doing X, Y, and Z. So I think that that is one of the implementation issues that would need to be addressed, you know, to the extent that the measure went into effect.
How well do we ensure that illegal internet firearm sales are not occurring?
I don't think that that's something that I can answer. I think that's a question that's better directed to DOJ.
Sure, but this would be modeled on that. So,
I think the concept is along that lines, yeah.
okay. And then moving on to page 5 of your analysis with regard to the surrendering of firearms at conviction.
Yes.
It says that if a court finds that an offender did not surrender his or her firearms within 14 days of sentencing, it is required to order that the firearms be seized. Is there any penalty for the recently convicted for not having surrendered? And is that a new crime? If I'm convicted, I'm now prohibited and I don't surrender.
So the court is going to be issuing it, issuing that warrant to the extent that there is probable cause. There's no penalty for the individual surrendering it, you know, actually like taking it and transporting and submitting it.
My question is there a penalty if I don't? Because the measure says I'm
Yes.
required to do so once I fall into the category of prohibited person.
I think it then falls, I think that might be a question that is better directed to the proponents, because I don't recall specifically related to that. I think my understanding is that it kind of falls into the queue of they're not supposed to have firearms and or ammunition, and so then it would be subject to removal the same way it currently,
Right.
current authorization.
So as we've been working with DOJ on the ever-growing mountain of prohibited weapons.
Yes.
And the growing number of names on our prohibited persons list. This, it sounds as you've described it, like an opportunity for us to keep that mountain from growing any higher and the list from growing any longer. It doesn't really address in any way the current
backlog.
The current backlog.
Correct. I think the intent of the measure is to obtain the firearms right up front,
Right.
you know, at the court process when you aren't, when you've been adjudicated. And so I think the intent is to kind of remove it at that point right away. But you're correct in terms of the existing backlog that exists. It wouldn't necessarily address that to the extent that the individual who's convicted does not have firearms that are already in the queue. So for example, they have firearms, they're already not supposed to have them, they get adjudicated for something else, and then when they get adjudicated for that new crime, they're supposed to provide a list of all of the firearms that they own and possess.
Right. Would this also impact those who have imposed upon them a restraining order?
So an individual who has a restraining order is generally a prohibited person.
But at the time that I have a restraining order imposed upon me, just as at the time I'm convicted of a crime that makes me prohibited, is there any similar process of seizing my weapons when I have that restraining order placed upon me?
I think it would fall in line with the precipitating, the event in question is the conviction. So it's the conviction for the felony, the certain misdemeanor, or if there is some sort of, I'm assuming, a restraining order.
But there's no conviction involved with a restraining order.
Oh, I'm sorry, that is correct. So this is predicated specifically on a conviction. So it's on the adjudication of a court process. So to the extent that there's a restraining order, I do not know if this would apply.
You're not sure if the measure's clear, or you're just not sure?
I think the measure focuses on the conviction. I don't know, depending on implementation, because the intent is, the broader intent is to remove firearms from individuals earlier on in the process.
Right.
So I don't know to what extent, in taking that broader interpretation, it would then be applied to restraining orders. The measure itself, in terms of the court process, is specifically related to conviction.
Got it. And is there anything that prohibits a court today from seizing weapons of those who are convicted of crimes that make them prohibited persons?
So that is something that is a question that we're having conversations with the various stakeholders about. Currently, the court provides and informs the individual when they're being adjudicated that they're not.
Sometimes not.
Yes, I think depending on what court you're in and depending, kind of who's adjudicating, the process could be different. But conceptually, the intent is currently under state law. The courts inform the individual. The question about whether there's authority to kind of seize the weapons at that point, I think we're not clear on, but we're having discussions about that.
Thank you. And Madam and Mr. Chairs, I'll just have one last question. And this one I apologize up front because I have minimal information to even offer you. But I had heard or read something to the effect that with regard to the surrendering of firearms or the interaction of this measure with our APPS program, that we're aligning it in some way with some federal, I don't know, statute or regulations, and the concern is that we might be surrendering some of our autonomy of our APPS program. Is there anything relative to aligning with the federal government with regard to APPS?
I haven't heard that, and I'm not quite clear. I mean, we're happy to follow up to the extent that.
So you did make mention briefly that there is an APPS, there is a federal database.
Yes.
And we have our own database.
Yes.
Are we deferring to the federal database in any way, or and how do those two interact?
No, so there's the broader federal database, and then individual states can have their own state.
We're one of the few that does.
We're one of the few, we're one of 13 essentially that chooses to process both the federal and the state, because by doing the federal as well, we can do the state. There are other states that do kind of a bifurcated system where in certain sales they go straight to the federal government, process those transactions that way, and then they process other sales with the state. We're not one of those states. So California is just, it goes straight through the state, the entire process.
Okay. Thank you very much.
Thank you. Senator Glazer?
Thank you, Mr. Chair. I had a couple questions on this issue of the large capacity magazines. First, Ms. Lee, do you know how many of those are in circulation today in California?
I do not. That's a question that's probably better directed to DOJ. We're happy to follow up on that and follow up with your staff on that.